I would like to introduce now the first of our speakers, Dr. Stephanie Holt from Trinity College, Dublin. So Stephanie is Associate Professor and Head of School in the School of Social Work and Social Policy in Trinity College, Dublin. Her research focuses on domestic violence with a particular emphasis on how children experience living with domestic violence and abuse and negotiate post-separation contact with domestically abusive fathers. Her research expertise involves engaging children in the research process with the objective of ascertaining and representing their views and experiences and informing best practice. She qualified as a social worker in '91, spending 9 years in professional practice before entering academic and research. So I'm going to hand over to you now, Stephanie, for your comments, please.
Many thanks, Sinead, for that introduction. Can you hear me okay? I just started my trusty timer. I can't actually see my presentation. I'm assuming it's loading there. I can't see it. Can other people see it?
No, I can't see it yet, Stephanie.
Okay.
I wonder if Maeve is working in the background, maybe to get it loaded up.
Well, maybe I'll just start with a kind of a general introduction, and you can let me know when it comes up there. So good afternoon, everybody. Delighted to see so many people in the room, even if it is slightly nerve-wracking that we're over the 100 mark. Many thanks to Sinead for the introduction, and to Karen and to One Family for inviting me to participate in this really, really timely webinar, as Sinead outlined, focusing on those child-centred reforms of the family law system we've been waiting for. As Sinead outlined, I have a particular interest, long-standing interest, I think, at this stage in family law, with a specific research focus on children's experience of post-separation contact, where there's been a prior history of domestic violence perpetrated by their father or father figure against their mother. I'm going to hold my hand up from the start of this presentation and acknowledge, I suppose, the very gendered nature of my research, which focuses on male perpetrators and female victims or survivors of domestic violence and abuse. That doesn't, of course, preclude other perpetrator or victim dyads, including female perpetrators, male victims, and same-sex couples. This is, however, what I do. It is my focus, and it also reflects the gendered nature of this issue as the predominant number of cases coming before the Irish courts and indeed internationally. I suppose while domestic violence and abuse is only one of the many issues that will be talked about today, as responded to by the family law system that demands reform, particularly when decisions on separation, divorce, custody and access are being made. I think it's important to note that it's not an insignificant concern, considering the international research evidence that at least 50% of those cases involve domestic violence and abuse. One would assume that while this statistic should demand that all parties to the case, which includes children and young people, are asked relatively routinely about domestic violence and abuse, the evidence, however, suggests that professionals virtually ignore the issue of DVA when considering contact or residency applications. This lack of attention to this ongoing harm to children post-separation represents, I would argue, and have argued before, a significant and dangerous shortcoming in the safeguarding responses to children. And it leads me to raise, as I have done in the title of my presentation, the question, is contact in the child's best interest? At the risk of answering that question before I've even started the presentation, I suppose the spoiler alert is that I do believe and argue that a meaningful father-child relationship is simply not possible. It's not attainable in the context of ongoing abuse. This is absolutely not about excluding men from children's lives. It's rather about prioritising child safety and welfare. A shift in emphasis, I would argue, is rather long overdue. I don't see the moving on button, sorry. Oh, there we are, okay. So in terms of an overview for this presentation over the next 9 or 10 minutes, I'm going to start with I suppose, one might say blue skies, but I think it's a relatively attainable look at what a new family system for children might look like, and briefly look at the evidence base on children, domestic violence and abuse and post-separation contact, because a lot of it's out there already. I'm going to touch a little bit on some of the powerful assumptions and presumptions, some would call them myths and misconceptions, that underpin current decision-making in the family law court in this context, and then briefly touch on what I suppose I see as needing to change.
Stephanie, you've gone on to mute. I think it might have been just when you were clicking on your slide there, maybe by accident.
Sorry about that. It was indeed, yeah. Okay, so I'm going to start with the title of this conference, which is Building a Family Law System for Children, and asking really of my presentation, you know, what does that look like? And sorry, this isn't moving on for me. It's not moving, okay. And I think for a family law system to be child-centered, I would argue that this system really needs to engage with that question about what is it like to be a child and live with domestic violence and abuse. In asking that question, we really need to position children as central to the experience of domestic violence and abuse, and actively involved in the family's experience of that. They're clearly not passive bystanders, but they are individuals who embody domestic violence with all of their senses. They see it, they hear it, and they experience the aftermath in ways that are considerably beyond what adults often comprehend. Can you hear that dinging? Sorry, this isn't moving on for me. Okay. Maeve, I might ask you just to move it on because it's not moving for me. It's fine, okay. So as a system that needs to understand DVA as coercive control, I think in recent times there's been this kind of notion of seeing domestic violence as separate to coercive control, and it's not. They're really one and the same thing. And in taking those as one and the same thing, there is a huge need to move from this physical instant model of domestic violence and abuse that talks about who did what to whom and when. That domestic violence and abuse for children is much more than the sum of its parts. There aren't any in-between downsides or episodes to this. This is a 24/7 white noise, as Stark referred to it as. And I suppose the foundations of that system also need to reflect an appreciation that child safety and best interests can't possibly be realised in a system that doesn't identify the risks that DVA presents for children, both pre and post-separation, and doesn't position children as rights holders with a voice or a choice. So therefore, we're talking about it really needing to address this dangerous combination of invisible risks and invisible rights. Closely related to that, I suppose, Peter Jaffe's assertion that separation is not a vaccine against domestic violence. We need to fully embrace this notion of the toxic presence of the absent partner or parent post-separation. On the next point then, the system really needs to, I would say, to do some navel gazing and really interrogate how do we construct vulnerability and risk, and acknowledge that child safety cannot be ensured in a system that only recognises vulnerability from father absence and not the risk associated with abusive presence. And I suppose in doing that, two shifts need to happen. The first one being this shift from a selective attention to children's voices that only listens to them when they want contact but ignores them when they don't. And also appreciating that the voice of the child isn't simply out there waiting to be captured. It's much more subtle and complex than that. And I think the other shift that we need to make is this shift from focusing on adult rights, which is the next point, and children's capacity to really kind of looking at this child in front of us. So not a child, as in the universal rights or needs of a child, but let's have a look at this child that's in front of this judge at this particular point in time. And in doing that, moving from adult right to contact to children's right to safety, voice and agency. So if we can move that on, Maeve. Okay, so very, very quickly, because all of this information is in the public domain already. People know it. I know I'm pushing an open door with some of these statements, but I think nonetheless they need to be said. So looking at the evidence base on children, domestic violence, and post-separation contact. And I suppose the very first one there, post-separation contact facilitates the ongoing and often unmonitored abuse of children and the non-offending parent. And this is important because the initiation of contact proceedings is often merely a tactic used by the abusers to continue harassment and control over women and children. And that continues even in their absence from the family home, which undermines and damages the mother-child relationship. In many cases, as we know, rigorous pursuit of contact is not followed by any follow-up with visits or with remote contact for children. This for me calls into question, as I know it does for others, the extent to which their wish for contact is actually genuine. Related to that, in the context, particularly of the legal system, there is a culture, a rather dangerous culture, I would say, of disbelief when women talk about abuse. Many women report being advised by their legal advisors not to disclose domestic violence abuse to avoid being labelled implacably hostile. When allegations about fathering capacity are raised, they're most likely considered false. Children's wishes similarly are subjected to selective bias, as I mentioned earlier, taken into account if they want it, contact, but disregarded if they don't. I think also that this description of the legal system as a clumsy tool for managing complex family problems is something we also really need to consider, because the legal system does have a very, very limited capacity to influence the quality of contact experienced by children and the quality of post-separation parent-child relationships. As such, the law is very, very good at adjudicating on the logistics of contact arrangements, so time and place, but its ability to influence quality or indeed regulate the appropriateness of such contact is considerably much more constrained. The subtle, but I think crucial difference between making contact work or just making sure that it happens. And I think finally, that last point there, that children do not benefit from the ongoing presence of abusive fathers in their lives. There's clear evidence to support that. So the available evidence then would pose really difficult questions for me, as for many people here, about the risks and benefits of contact in the history of post-separation, in the history of domestic violence. And it leads me to reasonably question how decisions are made within the legal system about children's contact with domestically abusive fathers. And I think on the one hand, there are quite powerful assumptions and presumptions about what's in a child's best interest, but I think they're underpinned by really, really unhelpful and dangerous myths and misconceptions. So this notion that, the first of these, I suppose, this notion that contact is almost always in the child's best interest, that positive outcomes for children are dependent on contact. However, I would question if we don't critically really engage with this assumption that contact decisions are made may not adequately consider risk and arguably prioritise fathers' rights over children's safety. The second assumption considers the history of domestic violence not really relevant when it comes to the adults being separated. Indeed, I think this overwhelming judicial focus on the future renders the past irrelevant, even where those past histories involved abuse. And that really severs the relationship between domestic abuse and risk to children, which is quite dangerous. And also the parenting of abusive men can be gauged, the parenting capacity can be gauged without any consideration of their abusive behaviour. So that disappearance of domestic violence, quite dangerous as it is only actually one half of a double disappearing act that Radford and Hester talked about in 2015. The second half of that disappearing act is quite relevant for today because it considers the absence of children's voices or children's experience in the decision-making process. It's also, I think, grounded in a powerful assumption that involving children in the decision-making process or hearing their voices in this context is not really in their best interests. Okay. Counter-argument to that?
Stephanie.
2 minutes? Okay. Counter-argument to that from children who have participated in research is that they believe really, really strongly in their right to be heard, but don't actually want the power to decide. So I guess the critical difference between having a voice but not really having a choice. Sorry, maybe move on there. So I suppose one kind of guiding, and I'm trying really hard not to be very reductionist with this guiding principle, but sometimes simple is good, less is more. And in thinking about a guiding principle that considers the impact of domestic violence, I'm guided by my good friend and colleague, Davina James Hanman, who talks about, look at what the abuser's doing, look at what the impact of domestic violence is, and do the absolute opposite. And I think interventions and systems could learn hugely from that, because at the moment, they are part of the problem of making the child's or the adult's world smaller. They compound the problem because they constrain the choices from which there are limited options really for the legal system. So if we just move on a little bit, and I think within that, the presumption of contact is only 50% of the option. The other option should be a choice not to have contact. The second part in this is that if we're only looking at the adult stroke father's rights, we're only looking at 50% of the rights agenda because we're not considering children. Also, if we only look at the future, we absolutely delete a lot more than 50% of the history that's needed to make informed decisions. And I suppose finally, with capacity, we need to be interrogating both a father's capacity to parent post-separation as much as we're assuming that a child doesn't have capacity to participate in the decision-making process. Sorry, Maeve. And I suppose underpinning all of that is the need to uphold a child's right to end an abusive relationship. So my final slide is, I suppose, if the legal system, if we're reforming the legal system with a view to making children's world bigger, we need to be really committed to expanding what Liz Kelly called that space for action. You can't expand a space for action where you don't see children, you don't hear them, and you don't understand what they're experiencing. But if you do expand that space for action, you have an opportunity to open up a canvas that includes real opportunities for safeguarding, and not just safeguarding against risk, but also promoting welfare. And in doing that and expanding that space for action, we are opening up a space that prioritises children's voice, children's agency, and children's rights. Thank you.
Thank you so much, Stephanie, for your comments. It's obviously a really sensitive and difficult part of this whole discussion, and I think your presentation has brought a lot of clarity, I think, to some of the dimensions of it. So thank you very much for that.